investment arbitration on regulatory autonomy. And these concerns have led to treaty terminations, renegotiations, and the development of new model BITs across the globe. And India is a particularly instructive case in this broader global recalibration. After the first adverse award in the case of White Industries Australia Limited versus the Republic of India in 2011, India has seen a flood of investor-state dispute settlement claims. And this had not only triggered a popular backlash against ISDS, but also resulted in the systematic overhaul of the Indian Bilateral Investment Treaty regime. And between 2016 and 2021, India unilaterally terminated over 75 BITs and started fresh negotiations based on the Indian model BIT adopted in 2016. India seeks to reduce the discretionary space of tribunals and to recalibrate the balance between the state's regulatory power and investor protection. And at the same time, India continues to seek foreign investment, position itself as an attractive destination for global capital, and engage with international dispute resolution mechanisms. This creates an inherent tension and also a productive one between protecting... Excuse me, I think there's someone who has activated his microphone. If we could silence those.
Just give me a second, I'm managing it.
No problem. I think now it's fixed, yes. So coming back, this creates an inherent tension and also a productive one between protecting legitimate investor expectations and preserving the state's ability to regulate in the public interest. And today's panel brings together perspectives from the judiciary and international arbitration practice to unpack these issues. We will explore how India's evolving treaty framework affects the assessment of state conduct, what meaningful protections remain available to investors, and whether India's approach reflects a broader global trend or a more distinctive national strategy. And with that, let me now turn to our speakers. And it is my great privilege to begin today's webinar with our first and distinguished speaker, Justice Ali Mohammed Magrey. And Justice Magrey is a former Chief Justice of the High Court of Jammu and Kashmir and Ladakh, and now acts as an arbitrator in institutional and ad hoc proceedings, and was designated Senior Advocate by the Supreme Court of India in 2023. And he currently serves as Senior Advisor at DSK Legal and as an arbitrator with the Dubai International Arbitration Center. He completed his graduation and LLB from the University of Kashmir and was enrolled as an advocate in 1984. Justice Magrey begins his practice in the district and revenue courts while also appearing before the High Court, and from 1986 served as standing counsel for several key public institutions. And in 2003, he was appointed Additional Advocate General and later elevated as Senior Additional Advocate General with additional charge of the Home Department, and appeared in numerous significant criminal, constitutional, civil, service, tax, arbitration, and public interest matters for the High Court and the Supreme Court of India, as well as in commissions of inquiry. Justice Magrey was appointed as a permanent judge of the High Court of Jammu and Kashmir in March 2013 and went on to serve as Chief Justice of the High Court of Jammu and Kashmir and Ladakh, taking oath in October 2022. We are truly honored to have Justice Ali Mohammed Magrey with us today, and we look forward to his valuable insights. Justice Magrey, may I request you to begin with your opening remarks?
Good evening to all distinguished speakers, members of the legal fraternity, industry colleagues, and participants. I am grateful to the Institutional and Industrial Dispute Resolution Center for the invitation to be part of this important dialogue under the IIDRC Across Industries series. I also thank the moderator and fellow panelists for their presence and engagement. I propose to speak today not about ADR as a concept in isolation, but about ADR as a living system, one that has quickly but decisively reshaped how disputes are understood, processed, and resolved across sectors. It's a privilege to speak today on the subject that has profoundly shaped the modern interface between international economic relations and public law, namely investment, arbitration, bilateral investment treaties, and India's evolving treaty landscape, particularly in relation to investor rights. Now, first, I will deal with investment arbitration, concept and rationale. In the contemporary global economy, cross-border investments are not limited to trade in goods. They involve long-term commitments of capital, including infrastructure, energy, telecom, manufacturing, and services. Such investments are vulnerable not only to market risks, but also to sovereign risks. Policy reversals, regulatory uncertainty, extortions, and discriminatory treatment. It is in this context that investment arbitration or investor state dispute settlement, ISDS, emerged as a mechanism allowing foreign investors to bring claims directly against host states before international arbitral tribunals, often under framework like ICSID, that is Investment State Dispute Settlement, and International Center for Settlement of Investment Disputes, or United Nations Commission on International Trade Law, arbitration rules. This was a significant departure from classical international law, where enforcement of foreign investor claims typically depended upon diplomatic protection, a political and discretionary process. Investment arbitration is a dispute settlement mechanism that allows a foreign investor having suffered harm as a result of measures taken by a host state to initiate arbitration proceedings on the basis of an alleged violation of rights guaranteed under an International Investment Agreement, II, concluded between the investor's home state and the host state. For such a claim to proceed successfully, three conditions must be satisfied. First, there must be a valid IIA in force between the claimant, home state, and the host state. Second, the claimant must qualify as an investor, and the affected asset must constitute a protected investment under the terms of the IIA. Third, the claimant must establish that the alleged harm arose from a breach of specific obligations of protection contained in the IIA. Investment arbitration, therefore, initialized a legal pathway offering neutrality of forum, enforceability of awards, and diplomatization of investment disputes. The normative framework, the backbone of investment arbitration is the BIT, Bilateral Investment Treaties. BITs are treaty commitments between two states in which each state undertakes to accord a minimum standard of treatment to investors from the other state. Most BITs contain protections such as fair and equitable treatment, FET, full protection and security, protection against direct and indirect extortions, national treatment and MNF, most favored nation treatment, free transfer of capital and return, and critically consent to arbitration. Thus, BITs create enforceable international rights for investors, sometimes described as a forum of arbitration without privity. Because the investor is not a party to the treaty yet, becomes a beneficiary with standing to enforce it. Number 3 is investor rights under BITs, scope and controversies. Investor rights under BITs are not merely contractual. They are treaty-based rights enforceable under international law. Their significance lies in the fact that, number 1, the host state's conduct is judged against international standards. Number 2, the dispute is adjudicated outside domestic courts. Number 3, the remedies may include compensation running into millions or even billions. However, these rights have not remained free from criticism. A major concern has been that certain treaty standards, especially FET and indirect expropriation, were drafted broadly and interpreted expensively by tribunals, leading to the perception that IIDRC can become a constraint on the sovereign ability to regulate in public interest. This concern is visible in disputes globally where state measures on taxation, environment, public health, financial regulation were challenged as treaty breaches. India's experience from bit expansion to treaty reform. India was an early participant in bit making in the 1990s and 2000. India signed a large number of BITs with relatively broad investor protections. But India's experience with arbitration led to a policy recalibration. The turning point is often traced to the case of White Industries Australia Limited versus Republic of India, 2011. In this case, the tribunal held India liable, particularly for denial of effective means due to the judicial delays. The award triggered serious introspection about the extent of exposure India faced under older BITs. Subsequently, India issued termination notices of mainly older BITs, sought renegotiation on revised terms, and adopted a new treaty template, the 2015 India Model BIT. Now, India 2015 Model BIT, central shifts. The 2015 Model BIT reflects India's effort to rebalance investment protection with regulatory autonomy. Some key reforms include, number A, redefinition of investment. India moved from a broad asset-based definition to an enterprise-based approach. This reduces treaty shopping and protects against purely speculative claims. B, restricting fair and equitable treatment. Instead of a broad FET clause, India adopted a more limited and defined standard, preventing tribunals from expanding it into a general guarantee of suitability or legitimate expectations. C, exhaustion of local remedies. One of the most significant features is the requirement that investors must ordinarily pursue domestic remedies for a specified period before initiating arbitration. This demonstrates India's preference for domestic adjudication first and international arbitration as a last resort. D, stronger regulatory carve-outs. India explicitly protects the state's right to regulate for public health, environment protection, labor and social welfare, national security, financial stability. Thus, India's model BIT represents a shift from maximum investor protection to a balanced treaty approach. 6. India's evolving treaty landscape, broader trend. India's approach reflects a broader global trend. Many states have sought to renegotiate older BITs, introduce interpretive safeguards, and reform ISDS. India today is pursuing carefully drafted new generation treaties, investment provisions within broader trade agreements, and a calibrated approach that protects investment but does not compromise sovereign policy space. Now, conclusion. Finding equilibrium. To conclude, investment arbitration and BITs remain significant tools for fostering investor confidence and attracting foreign investment. Yet their legitimacy depends upon maintaining an equilibrium between investor protection and state sovereignty and public welfare regulation. India's evolving treaty practice demonstrates a conscious attempt to craft such equilibrium, ensuring that investors receive protection against arbitrary treatment while states retain the democratic space to legislate and regulate for public interest. Thank you very much. I hand over back to you. Anything left, we'll deal with the discussion with the panelists and with the participants also. Thank you very much.
Thank you very much. Thank you very much, Justice Magrey. I think it was very helpful to get back to the basic terms such as investor, investment, international investment agreements, and also naming some of the investor protections such as fair and equitable treatment, expropriation, full protection and security. So thank you very much for clarifying the basics and also already going a little bit more into depth. Then with that, I would like now to move on to our next distinguished speaker who will further enrich today's discussion. Mr. Bhushan Satish is a New York and India qualified lawyer in the firm's global disputes practice, where he focuses on international arbitration and complex commercial litigation before US state and federal courts. Bhushan has served as counsel and tribunal secretary in more than 50 arbitration and litigation matters spanning various industries. His cases often deal with social and political issues involving states and state-owned entities. Amongst his recent victories, he successfully represented Global Healthcare Systems Private Limited, an Indian digital healthcare company, in a multi-pronged dispute related to a failed SPAC transaction with parallel actions before the Delaware Bankruptcy Court and SDNY, in addition to various civil and criminal proceedings before Indian courts. Despite facing an $150 million ICC arbitral award against Glocal, he and the Sidley team obtained a highly favorable settlement within a month of being retained, resulting in a net gain in value for Glocal of $27.5 million. The win was widely covered in the press and acknowledged by the American lawyer in their Litigator of the Week award. Bhushan has trained and worked in the US, UK, South Korea, Switzerland, India, and France. As the first Indian lawyer in private practice in Korea, he is equally comfortable and familiar with common and civil law traditions. Bhushan holds an LLM from Harvard Law School and University of Geneva and Geneva Graduate Institute. May I now invite you to share your opening remarks, Mr. Bhushan Satish.
Thank you for that very generous and warm introduction. I'm going to jump straight to it, especially given the time we're keeping, and just as Magrey is very helpful context setting of where we are right now in sort of India's journey, as it were. I wanted to perhaps focus more on how the treaty policy that India has adopted has changed in the last 5 years. And of course, there'll be time to get into the details of it. But sort of big picture, I would say there are at least three patterns emerging, and that's number one, the separation of investment treaty or investment diplomacy from investor state arbitration and really enforcement of investor obligations and rights. And number two is the procedural sort of gatekeeping of consent in India's view, enforceable BITs. And the third is, the resulting sort of two-track arbitration outlook, where you have, in the case docket, significant exposure to legacy cases, whereas really the results of the changes in the model BIT haven't touched practice just yet. So we'll see, how that pans out. On the first point on decoupling, I would say you can sort of see very clearly between 2022 and 24, you had all these FTAs, be it the India UAE SIPA, the EFTA India TIPA. All these FTAs do contain investment promotion cooperation architecture, but not really any investment chapter as such, and certainly no ISDS provision. And I think that sort of really places India within the broader global legitimacy critique of ISDS, where unlike, for example, the EU, which has taken this decision of just change the adjudicator, go from investment treaty arbitration to an international members court, I think India's approach has been more calibrated, more careful, and I would say more fundamental, in that you deny the investor cause of action in the first place by not having this category of instrument. The second is on sort of gating what kind of rights are given and are enforceable. And the clearest example of this is the India UAE BIT, and there are a couple since then, including the India Israel BIT, where although there are bilateral variations, the common design logic really is that you narrow the investment definition, came in the substantive standards, away from open textured FET kind of debates, and really sort of preserve robust carve-outs, especially around taxation and security. And the third pattern in that sense is that we are left in a situation where a lot of the docket, be it the recent Vedanta $8 billion HCL related arbitration or Panther goal arbitration, all of these are really sort of legacy cases, right? And They arise from terminated treaties with survival clauses. And given that a lot of the termination happened in 2017, I think these cases, at least the initiation of new cases, are at its tail end, and they would come to an end, I think, next year, 2027. So in terms of a closing, remark, I would say if there's a single proposition for the last 5 years, I would say India is not anti-treaty. It's more anti-open-ended consent. And it's the building of a portfolio in which investment cooperation can exist without investor adjudication and enforceable BITs. And for council, that shift in the center of gravity, will be felt in the coming years, and that the next generation of Indian disputes will be litigated less on broad fairness narratives and more on consent architecture. By which I mean what was agreed, what conditions were met, what categories of measures were carved out, and so forth. That's my time. Back to you, Helen.
Thank you very much, Mr. Bhushan. Satish, I think these 3 points are very precisely, and they're really good, kind of explained your first assessment of the current situation. Therewith, I would, and building on these valuable insights, I would like to invite our next speaker, Mrs. Ramya Raman, to take the session forward. Mrs. Ramya Raman is an associate partner with P&A law offices focusing on investor-state arbitrations. She was previously an in-house legal consultant in the International Investment Treaties and Framework section of the Department of Economic Affairs, Ministry of Finance, Government of India for over 6 years. And she was a member of the official delegation representing the Republic of India in negotiations of bilateral investment treaties and investment chapters of free trade agreements, and handled investment treaty disputes of India and advised on related policy matters. Ramya is an India-qualified lawyer with a keen interest in international investment and trade law, investment treaty arbitration, and public international law. She holds an LLM with distinction in commercial and corporate laws from Queen Mary University of London. And with that, Ramya, I invite you to offer your opening remarks.
Thank you, Helen, for this kind introduction. Good evening, everyone. Good evening again to my fellow panelists, Justice Magrey, Dr. Jena, and Bhushan. And thank you, Neha and IIDRC, for giving me this opportunity to speak about this issue. As Helen has already introduced me, I'm a partner with P&A law offices. I'm based out of Delhi. And I've spent just over a decade now focusing exclusively on investment arbitration. Started off with policy work and negotiation. I was fortunate to work with the Government of India and work on a daily basis on negotiations, understand international diplomacy besides international law and other public international law issues. And now I've moved to practice, and I'm working with P&A law offices for a while now. Dealing and mostly representing India in BIT arbitrations, and I continue my policy advisory for the Ministry of Finance. So, of course, this is a issue, of course, which is very close to me. I've I think come at the time I started working with India at the time when they just commenced their reform process, and as the earlier speakers had set out, how there has been a evolution in the Indian landscape, and also, as Bhushan mentioned, about certain key issues that one needs to focus today with the changing landscape over the last couple of years, with the shift of whether there is going to be investment protection or investment promotion. These are definitely issues that are being looked at, and specifically to speak about how, the focus of this webinar and discussing about state conduct vis-a-vis, investor rights. This is always, we always look at it from two perspectives: one from a policy perspective, and one from a practitioner's perspective. So definitely there is always a focus on how, because this, the whole starting point, we all need to relook at why investment treaty. What is the purpose of an investment treaty? Why an investor is invoking a dispute under investment treaty and not under a contract. And, the answer to that, I think, would help us in understanding, all these reforms, all the questions, all the disputes on why the state is conducting itself to reform certain provisions of the treaty, or why the investor, even today, is still facing a lot of challenges. Like one of the points that Bhushan mentioned was, of course, consent. And also another very important issue is about enforcement of treaties, even from the investor's perspective. Because there is obviously a lot of, we've seen disputes, we've seen outcomes, but there is statistics on how there are a lot of unpaid awards even today across the globe in various jurisdictions. So one needs to also look at it. But I'll stop here and we'll continue discussing this. Thank you.
Yes, thank you very much, Ramya. I think this balance between investment protection and investment promotion and the state conduct on this one hand, on the investor rights on the other hand, are a really hard balance to strike in the end. But we are very happy to dive deeper into it later on in the discussion. So thank you very much for the first insight into the problematic itself. And as we carry this conversation forward, it gives me great pleasure to introduce our next speaker. Dr. Argha Kumar Jena is the founder of Transnational Legal Advisors, a boutique law firm with offices in Mumbai, Delhi, and Kolkata. And as a part of the firm, he advises and represents clients from India, Europe, and the Middle East in matters concerning cross-border investments, sanctions, international trade, international investment contracts, and international dispute resolution. Currently, he also serves as a member of the research task force of the Roma Tree Unidroit Center for Transnational Commercial Law and International Arbitration, and is also country reporter for the CELIS Institute, Berlin. Previously, Dr. Jena has served as a senior legal consultant at the Ministry of Finance, where he was part of the teams that negotiated several bilateral investment treaties and investment chapters of FTAs. Further, he has been part of legal expert teams and law firms in India, Italy, and Germany, while advising and representing clients in matters of commercial as well as investor-state disputes. May I now invite you to share your opening remarks. The floor is yours, Kumar.
Thank you, Helene. First of all, it's quite the challenge following stellar colleagues like Justice Magrey, Ramya, and Bhushan. But what I'll do is I'll try to set the stage or set the foundations for what the following discussions would be. And just zooming out of India a little bit, I think something that I often say and I believe that investor-state arbitration, while being a unicorn in its own nature, is also in its adolescence. It's just barely been 4 decades since APL versus Sri Lanka, and we have over 1,400 cases already. The numbers alone tell a compelling story in my estimation. In 2024, in my recent readings, if I'm not wrong, the investors have initiated more than 58 new arbitrations, or half relating to extractive activities and energy supply, and approximately 50%, 55% of the new cases brought against developing countries. Now, we can, of course, use these pieces of information to draw different kinds of inferences, but there was a little bit of insight on our work at the UNITWA as well, that when we started looking, or when we realized that contractualization of rather what would otherwise be treaty obligations are taking a higher speed or in adoption in modern investment contracts, we do realize that most of the contracts available for study were also from the extractive industries. But in any case, between 2015 and 24, the average amount claimed in these awards were nearly about $1 billion, while the median award was around 40 million. However, this is the new era of the awards shows that there's a decisive shift towards higher stakes litigation. That means one could infer that there is a higher understanding or a higher confidence over what constitutes international dispute resolution mechanisms. Now, this escalation has also sharpened the urgency of the reform, as I believe the forum already is very, very well aware of. But just to summarize, that the reform is indeed underway on multiple fronts. The UNCITRAL Working Group 3, which is, of course, was initially mandated to affect or come up with recommendations for procedural reforms of what constitutes investor-state dispute settlement mechanisms, is now in its 53rd session, has advanced several draft statutes for the advisory center, the standing mechanism, alongside the guidelines for the calculation of damages and compensation, one of my more favorite reforms or would-be reforms. However, in addition to that, you see the ICSID's 2022 rule amendments, the very extensive modernization in over 5 decades of its existence. And they've also introduced mandatory electronic filing, expedited arbitration, enhanced transparency, and stricter timelines in matters of umbrellas of reforms. Now, they're also negotiating with UNCITRAL to replace ad hoc arbitration with a permanent adjudicatory body. And as our friends in the European Union will tell us, that the European Union is quite championing in its idea of multilateral investment court and a permanent rooster of arbitrators, or in several ways. While the intra-EU saga still continues in ways which begs legal complexity, or rather a deeper understanding of what might constitute treaty interpretation. These developments, I believe, underscore a tectonic reality. The old stock of unreformed treaties still underpin the vast majority of pending claims, even as new instruments chart a fundamentally different course. Be it new principles for investment contracts, be it new generation treaties, we are yet to see how those things play out and whether any of these reforms actually reform the reality of what has come to be. I think it is against this backdrop that we gather today to interrogate, to debate, and to shape the contours of investment arbitration as a regime in the decade ahead. And I believe that doubt is the primary yardstick of conducting a discussion. So I wish everyone a wonderful discussion ahead, and I hope doubt prevails.
Thank you very much, Kumar, for your first assessment and also for shedding light on the dispute settlement mechanisms that exist and that are potentially being reformed, or also the potential in general of how could they be managed in a different way. So with that, I would first of all thank our speakers for their opening remarks, and now look forward to engaging with the subject of investment arbitration in greater depth. And I would like to begin with the question of what makes investment arbitration different, meaning investment arbitration occupying a distinctive space within international dispute resolution itself. And therefore, from your perspective, what are its defining features, and what would you consider to be then the most significant challenges it faces today? And Kumar, we already heard some of the doubts, or that we should always question the current state. So starting with that, I would like to invite Mr. Bhushan Satish and Dr. Argha Jena to share their views on these questions. Mr. Bhushan Satish, may I ask you to give your first initial thoughts on that?
Absolutely. I would frame it as ISDS really is the only game in town, in the sense that is the only scalable, enforceable mechanism we have for investor-state disputes. Now, whatever one might think of the regime's pathologies, and God knows there are enough and more. Investment arbitration remains today the only globally operational system that gives investors direct standing against states and produces awards with meaningful cross-border enforceability. Now, domestic courts are rarely perceived as neutral in disputes implicating the state itself, and I don't think that's a controversial position to take. And diplomatic protection is, of course, politically contingent and structurally, exceptional, as is interstate adjudication, which is not designed to process the kind of high volume of individualized, very fact-intensive compensation claims. Now, Having said that, what's also distinctive about investment arbitration is that while one often touts and this finds a lot of space in commentary and doctrine in that it depoliticizes disputes, I would suggest that as a practitioner, it's the opposite. Very often, clients and investors are just stuck in this quagmire of bureaucracy and in many ways, their troubles and problems are unexceptional in the domestic court framework. And so I would suggest that it's the opposite, in that when an investor says that, all right, I want to initiate a claim, they want to politicize it. They see it as a way to get a direct hotline to the decision makers and basically cut through the morass of bureaucracy and the sort of stifling framework where you really aren't able to get anyone to make a decision and stick to it. So in that sense, there is a balance, here between coming to an adjudication and an outcome that's enforceable, and at the same time using investment treaty arbitration as a means to settle, really. And I think the sort of political and commercial reality also is that no investor that has any real skin in the game, in a sense that it's exposed to the economy, it's exposed to continuing contracts and commercial relations, wants to actually cross swords with the government, and therefore a lot of these cases are just basically initiated in order to get a sympathetic ear and to reach a settlement that works for all, and because there is no true functional substitute, the system is also asked to carry more weight than I would suggest it's designed to build to bear. Now, a lot of the disputes that come up before tribunals implicate serious issues of public law. I think the energy transition, sanctions, taxation, a lot of it in India, crisis measures during COVID, and all of that is mediated through a model optimized for private dispute resolution. And the result is predictable in that, there is sustained pressure around legitimacy and optics of who are these adjudicators and who are these arbitrators, and why does it look, I think the controversial sort of description is that it's pale, male, and stale, and ultimately, keeping aside whether or not there are inconsistent interpretations in a formally non-precedential structure, the fact is that these things are expensive. They carry on for long. Transparency is an issue, and so are arbitrator ethics. And states are permanent. They are there forever, and therefore, in many ways, these are not just mere process issues, in that it takes a lot for an investor to say that I will risk my not just present prospects but future prospects in a country, and I'm going to actually litigate this arbitration or this claim until forever. And this, I think, I would agree with Ramya when she says that ultimately these awards are not getting enforced. And so surely there is more to it than just getting the money back. Oh, back to you.
Thank you very much, Mr. Satish. There were so many interesting aspects already in this contribution. So I'm very glad that we could hear your first insights, also this perspective from the investor, and that it is a lot of risk that he's also taking. And then also questioning whether the investor wants to initiate or politicize by initiating these processes. So thank you very much for giving these first train of thoughts that we can still linger on later on. There was one sentence that stuck out to me, which is you said that the system is asked to carry more weight than it is designed to build to bear. And maybe throwing this again into the room, may I ask you, Kumar, to react to some aspects that Mr. Satish already mentioned, and maybe give your further insights into these problematics?
Well, I think when it comes to whether the system was designed to take a certain load, uh, it's only a matter of perspective. So I can only provide mine to that effect. But well, before going to that, just to the question on the floor about what makes investment arbitration different. I think it is meant to be the question of last resort, something that Bhushan, I think, was very clear about, and I think that everyone who has had any sort of interaction with the regime would agree in one way or the other that no large investor who is operating in a foreign country wants to get into the ring with the government in an international forum, because that would effectively mean the final nail in the coffin. So, escalating a dispute to an investor state arbitration level is something that has several predicaments. And one needs to take that with a pinch of salt. So, in other words, we have often seen that most of the landmark or some of the more popular um, investment arbitration cases being studied in academia or being debated over the period of time, be it the Yukos saga, be it the cases emerging from the 2001 crisis in South America, or be it the Vodafone case in India. Says it was all of these cases have effectively seen in some way or the other it was an escalation. Whether or not there was a mandate for exhausting local remedies, every investor went into or thought of, or I wouldn't say thought of, was in a way we could say that they were constrained to initiate an investor state arbitration, because it largely because they saw no success or found no success, or they believed that they could find no success in pursuing local remedies. And it is not an academic question so as to evaluate the level of partiality that an investor might face against the state in their own courts, but uh, rather the question of what constituted the manifestation of political risk that forced the hand of the investor to initiate a claim. Now, while that is one part of the reality, the other part of the reality, I think all of my colleagues who, and probably Ramya more than anyone else, can approve or disapprove, is that there are several cases which do not see the face of arbitration. They're just claims, or they're just requests for arbitrations that come into somebody's post box, and those cases never see the light of the day, because they are either frivolous, or they do not, or they are tackled in a manner that does not require a full-fledged proceeding. Now, does that mean that the state conduct is something that is questioned unilaterally? The mechanism of what a request for arbitration can be is something that might give the investor a unilateral hand to evaluate the state conduct in one manner or the other. However, the system is such, the investor state arbitration in its true ways, or in true meanings, as my mentor would often put it, is the Champions League of law. And that means that it is also one of the most expensive litigations or dispute resolution mechanisms for an investor to pursue. As a cross effect of that, an investor would actually seek credible advice before initiating or pursuing a claim of the sort, which is if there is there is a very interesting book in the market called The Myths and Realities of Investment Arbitration by Dr. Susan Frank. I think that book itself puts out the realities of what the fiscal realities of pursuing investment arbitration is. So while the investment arbitration procedures being or investment arbitration as a regime being what it is, a unicorn of its sort, giving large private players the freedom and the forum to hold states accountable. The regime in itself, like I said, and I believe personally, is in its adolescence. And while there are several systemic matters or systemic features which rather puts the check onto frivolous claims, it cannot be unilateral, so to say, in either of the in either whether it is about initiating the claim or be it evaluation of the measure that caused the claim. That said, the significant challenges, I believe, are rather procedural more than rather than substantive, because both parties are atypically opposite to each other, uh, which is um, which is quite the contrast compared to commercial disputes or other international disputes, so to say. I think for now that would be all. But if there are follow-up questions, we'll discuss accordingly.
Yeah, thank you so much, Kumar. I think it was very helpful how you clearly pointed out the systemic features of this mechanism and also named some of the procedural challenges that lie ahead. Moving from this investment screening mechanisms and challenges concerning ISDS, I would like now to come to the balance between investor protection and the state's right to regulate. The introduction of India's model BIT in 2016 marked a decisive shift away from the broad investor protections embedded in its earlier treaty practice, and it signaled a reorientation, prioritizing regulatory leeway, procedural prudence, and a restrained scope of investor protection. And against this backdrop, an important question arises on how should tribunals assess state conduct under modern BITs that explicitly emphasize states' regulatory autonomy and public interest objectives, such as India's model BIT? And maybe more broadly, to what extent will this shift toward more state-oriented BITs transform the practice of investment arbitration? Therefore, I would like to invite Mrs. Ramya Raman again to address this question.
Thank you, Helen. I think I remembered in your opening remarks, one of the points which you mentioned was, particularly with respect to the model BIT, is the reform is also to reduce and aim to reduce the tribunal's discretion. And I think somewhere where I differ in this, and I start my comments on this, is that rather than reducing the tribunal's discretion, I think the attempt in terms of drafting to come out with a model BIT as a response or reaction to whatever India's experience has been is more to, I think, provide guidance on certain issues and ensure that there is the objectives, the regulatory context and objectives of the state is respected while the tribunal is looking into certain aspects. And a lot of evolution, and of course, as already Justice Magrey in his initial comments very helpfully and elaborately set out the the various changes which the model BIT has undergone in terms of defining certain concepts. I think there are a few which are critical and not probably just focusing on just Indian BITs, but we've of course over the last decade seen a lot of BITs across the European Union and other African nations and India, of course, to see a lot of drafting changes. And I think that there is the attempt has been that what the state is from a perspective of right to regulate is expecting that there should be certain understanding of the policy choices of the government, and that is why you see there are more exceptions, for example, in the scope or the exceptions in the form of general exceptions or security exceptions. And again, in terms of substantive obligations, there is certain attempt to perhaps see where there is a balance between what is the proportionality that must be exercised by a tribunal while looking at the treaty and interpreting the treaty while deciding on whether there is a breach of a substantive obligation. So, for example, if we take the fair and equitable treatment, and we see that the model BAT does not even use the term fair and equitable treatment, but replaces it with certain limited grounds, which perhaps leads to certain similar meaning, like fundamental breach of due process or discrimination. Again, you see there are adjectives used to increase the threshold. So it is not just discrimination, but targeted discrimination or manifestly arbitrary conduct. So I think the attempt of the state in the process of reassessing its treaty negotiation from a policy perspective is perhaps to ensure that only legitimate cases, and something which of course Argha and Bhushan you mentioned. I think the common thread was no investor is they're not serial litigators trying to force the state into a dispute, but because they know they have to survive in the same economic system. But it is more of a last resort. It is expensive for the investor as well, but still they attempt to do it. So from an investor's perspective, there are expectations on what protection they can get under the treaty. But from a state's perspective, I think the attempt is to ensure that the treaty is interpreted correctly. And in this process, there are some changes that we see in treaties. For example, both procedurally and substantively, as I gave an example of one substantive change. Procedurally, we see one point is that I think there is this point that which is very important in my view, is that there is an expectation that the tribunal must acknowledge its limits in terms of its institutional competency, and that is why you see limits in the scope of the ISDS, that they cannot be an appellate body to the decisions which are taken by, say, for example, the Supreme Court of India or any other executive decisions. So I think this is again perhaps something which is I would not specifically say whether this is very conservative or this is appropriate, but I think this is an important change which we must look at. That is the limitations to the scope of the ISDS, because that is what is going to shape the tribunal's competence in finally determining the dispute and whether it's admissible or not.
Thank you so much, Ramya, for clarifying also the challenges that lie ahead for the tribunal, that on the one hand also must accept its limits, as you have mentioned, but also challenges regarding finding the right proportionality that must be exercised by tribunals, and also trying to look at the objectives of the state in a good balance regarding the state's and the investor's perspective, and bring those two perspectives together. So thank you very much for your clarifying thoughts on that. And having examined the balance between investor protection and regulatory autonomy, we now turn to the role of domestic courts within the investment arbitration framework. India's model BIT places strong emphasis on the exhaustion of domestic remedies and requiring investors to pursue claims before domestic courts for a defined period prior to the initiation of international arbitration. And how does this recalibrate the relationship between domestic legal systems and international investment arbitration? And does it enhance or undermine investor confidence? I would like now to invite Justice A.M. Magrey to share his perspective on this question. Justice Magrey, I think we are not able to hear you. I think you're still muted. If you could turn on your microphone. It's still turned off at the moment.
Neha, if you have master controls, perhaps you could unmute Justice Magrey's microphone.
You're still not audible, unfortunately.
I think somebody who's hosting the meeting can assist in unmuting.
Having the option to ask to unmute, it's like no, the direct option to unmute him. Mr. Magrey, please ask your team to see if they can. यहाँ एक किन्होंने कर लिया।
Maybe in the meantime, if any of the other speakers would like to share their thoughts on the exhaustion of local remedies, or in general this dimension between the legal domestic system and investment arbitration, then you're free to share your thoughts.
Well, I'm happy to jump in. Sorry, my video is gone for some reason. All right, back online. I'm happy to sort of jump in just very quickly in this, and this it goes to Ramya's point on carve-outs, right? That you don't, in principle, the idea that a sovereign would be okay with a tribunal second guessing its highest court, and therefore you have these sort of carve-outs, whether it was in the joint interpretive statement or in the newer treaties. I'm not sure how far that goes, because like when I, for instance, am advising clients and investors, that just means that you will say, all right, we won't be challenging the Supreme Court's decision, but the underlying sovereign action that's been placed before the court for adjudication. So that just sort of moves the goalpost and doesn't really do much in terms of so it's to large extent, I suspect it's an issue of optics, in that one doesn't want a Supreme Court judgment to be second guessed, but ultimately I'm not sure how effective that carve out really is.
Thank you very much for your input. As far as I see, we're still not able to get Justice Magrey speak on this topic. But besides this point, maybe also regarding the time limits that we have today, I would like...
Helene, we have Justice Magrey over here, and I guess his mic is also working now.
It is working? Okay, then yes. Thank you very much for telling me. I would like to invite Justice Magrey then to share his perspective.
This reinforcement of judicial sovereignty, am I audible now? You hear me?
Yes, we can hear you.
Thank you. India's model BIT appropriately restores the primacy of domestic courts by recognizing them as competent, independent, and constitutionally grounded institutions capable of adjudicating complex investment disputes. Majority of the legal system, the accession requirement reflects confidence in India's judicial system. It signals that India no longer views international arbitration as a necessary substitute for domestic justice, but as a complementary safeguard. Balanced investor protection. Investors are not denied access to international arbitration. Rather, it is structured and sequenced. This ensures that international arbitration is invoked only where domestic remedies prove ineffective or inadequate. Filtering of frivolous or premature claims. Requiring prior recourse to domestic courts helps screen disputes that can be resolved internally, preserving international arbitration for genuine treaty-level grievances. Regulatory stability and policy space. The approach protects legitimate regulatory action in areas such as public health, environment, and economic policy, thereby enhancing long-term stability for investors and the state alike. Enhanced investor confidence through predictability. For serious investors, legal certainty, institutional accountability, and rule-based education matter more than speed alone. India's model BIT offers a predictable, law-driven pathway for dispute resolution, alignment with evolving international practice. The model BIT reflects a broader global shift towards recalibrating investors' state dispute settlement, positioning India as a norm shaper rather than an outlier. Thank you very much.
Thank you very much. With that, I would like to close, and I would like to invite each of our speakers to briefly share one investment arbitration case that they find particularly important, interesting, or perhaps even a little unusual. And please also say a few words about why this case stands out for you. But I would like to remind all the speakers to make this in a brief manner, as we are running out of time a little bit at this point. But I would like to first hear from Justice A.M. Magrey, and then Mr. Bhushan Satish, followed by Mrs. Ramya Raman, and finally Dr. Argha Kumar Jena. So, Justice Magrey, is there one case that stands out for you particularly?
Yes. I would like to invite each of the speakers to brief. If I were to mention one Honorable Supreme Court of India decision that I find particularly instructive in the investment arbitration context, it would be Vodafone International Holiday BV versus Union of India, reported as 2012 6 SCC 613. What makes this case unusual is that it was not, strictly speaking, an investment arbitration case. It was a tax dispute. Yet its impact was felt most strongly in the investment treaty and arbitration space. The core question before the Honorable Supreme Court of India was whether a genuine offshore transaction structured and completed outside India could be taxed in India merely because the underlying assets were located here. The Honorable Apex Court answered this by stressing the importance of legal certainty, predictability, and clear legislative authority in tax matters. It held that taxation cannot be imposed by implication or through administrative interpretation. From an investment standpoint, this judgment was a clear affirmation of the rule of law. It showed that India's highest court is prepared to apply settled legal principles even where significant revenue interests are involved. What makes the case particularly relevant today is what followed the judgment. The retrospective legislative amendment and the investment treaty arbitrators that came thereafter highlighted an important distinction between judicial decision making and state policy choices. It becomes clear that investment disputes often arise not because of court judgments, but because of how states respond to them. In this sense, the Vodafone case offers an important lesson that is reflected in India's current approach to investment treaties. It underlines the need for early in treaty obligations, predictability in state action, and consistency between domestic legal process and international commitments. For anyone seeking to understand how domestic courts, state conduct, and investment arbitration interacts, the Vodafone case remains a particularly valuable in reference point. Thank you very much.
Thank you very much. With that, I would like to give the word to Mr. Bhushan Satish to share one particularly interesting case in his eyes.
Sure thing. I should say, I should have started with this. Views expressed here are pretty personal and are not representative in any manner of Sidley or any of my past employers. and I say that because I wanted to use the example of Lone Star versus Korea as a trigger for a broader issue, which is how do you deal with parallel commercial arbitration that run alongside treaty disputes? Because parallel commercial arbitrations, are no longer sort of a peripheral case management. Left their mic on. Now, just very briefly, it's an interesting case because it really brings to the fore a lot of doctrinal pressure points, stuff like touching on due process, evidentiary theories, double recovery, and how different tribunals have handled cross-pollination of evidence in meaningfully different ways. And Lone Star really sort of crystallizes the risk when a treaty tribunal leans on a commercial award, not merely as background facts, but as key proof about contested facts involving a state organ that may not have been a party to the commercial arbitration. Now, irrespective of where we go, whether it's right or wrong and how to do it, it certainly makes for a very interesting reading.
Very interesting aspect of this overlap of commercial arbitration and investment arbitration. So thank you very much for sharing. And I would like to continue with Mrs. Ramya Raman, please.
Thank you. Thank you for this question. And I mean, obviously, as every case has its, interest and, what we've learned as either as lawyers or practitioners. I was, a couple of weeks ago, I was looking at something around general exceptions, and I came across this case and called Continental Casualty versus Argentina. And this was one of those cases among many of the Argentinian cases with respect to financial crisis. But I thought it was perhaps it was interesting to me and possibly relevant to what we're discussing today with respect to state conduct, because it was one of the cases before I briefly mentioned the facts or what its outcome was that even under the older generation BITs, tribunals they have and they could exercise restraint in, if I could use maybe for lack of a better word, while reviewing a state's conduct taken in good faith, because this was a case where Argentina came out with certain, Casualty was a insurance company, and this was a dispute under the Argentina US BIT, and this was regarding Argentina's measures on, pacification of basically mandating all the companies to mandatorily convert dollars into pesos under their contracts based on the rates that the government of Argentina prescribed, and having some restrictions imposed on capital transfer. And this was in response to their financial, crisis that Argentina was undergoing. And I think the interesting points are, because I would ask someone to, of course, read through the award. But I think why I found it, interesting was because for those who, have read about, generally about BITs, we know how general exceptions and, the non-precluded measures, I mean, the provisions which, reflect non-precluded measures versus the necessity test that is taken. In this case, of course, the tribunal found that Argentina was correct to take certain measures, while they did impose certain liabilities on the state as well. But largely, it was supporting the state's conduct. And I think in today's, the way today's global financial order is, I think it's a very relevant case to look at both the necessity test, and also the tribunal not only went into investment treaty concepts, they also looked into the WTO. They went far as back as the United States FCN, the Friendship Commerce Navigation Treaties, and looked at principles. So I think this was a very good example of a case which I recently came across, although it is more than a decade old. I think it's of 2008. But it combined all the principles which I think an investment treaty lawyer should know: international law, arbitration, financial law, corporate law, and I think this just combined everything for me. And I also found it relevant to today's topics. So this is something that I wanted to. I think I would ask everyone to have a look at this award. Thank you.
Thank you so much, Ramya. I really think that this aspect of general exceptions and security exceptions, which we can kind of see a trend at the moment, that more and more BITs really include also these kind of exceptions, is a very interesting aspect, also in regard that WTO panels already have assessed these security exceptions regarding the GATT. So yeah, very, very interesting, and a point that was missing so far. So then last but not least, I would like to ask Kumar to share his last proposal of a case that we should not miss out on.
Well, I think looking at cases would be quite interesting. But the fact that it is quite fitting that Ramya sets the stage for questions which are rebranded as economic security questions these days. Because I mean, we all know how machine learning was rebranded as AI. We saw AI-powered washing machines for some reasons, and I did not know what they did. But thankfully, economic security is not that obscure. So now, when it came to economic security at the time of the financial crisis, or excuse me, when the financial crisis forms the basis of several investment treaty claims, that already underpins what the expression economic security might mean. And in today's world, people who dabble into law and policy together might already know that semiconductors are the new generation, or the new yardstick of what constitutes world power. And the chip shortage of 2020 also kind of cemented that thinking. And now, be it India or many other countries, the intervention of our northern neighbors of India in terms of several opportunistic takeovers, or termed otherwise, have formed many thought processes, or provoked thinking in terms of economic security in the new generation. And semiconductors being branded, or wouldn't say branded, but at least annotated as critical technology in most jurisdictions, have have created a very interesting recent news. If anybody has followed the the Wingtech's investment in the Netherlands in a company called Nexperia. Now, this is a case which, like I said, I do not know whether this case is going to really come up and become one, but it is definitely seems to be a case in the making. I mean, for the benefit of the listeners, the so-called Nexperia dispute arises from a Dutch state intervention in a Chinese-owned semiconductor firm, raising issues at the intersection of economic security and investment protection. Now, Nexperia is controlled by China's Wingtech, a semiconductor giant, and it operates chip plants in Europe, and is indirectly, because of the Chinese investment of Wingtech in Nexperia, is covered under the China-Netherlands BIT. Now, in 2025, the Dutch government took control of Nexperia under emergency economic security legislation. Now, citing governance failures, risk of sensitive technology and know-how being transferred to China, and temporarily restricted major decisions and asset transfers and hiring. So this was the first state conduct. And although some measures were later suspended, or the Chinese government rolled back on some of them, the Dutch government rolled back on some of them, Wingtech still maintains that the intervention shattered the company's integrated Europe-China business model and erased billions in value, which is effectively is the modern thinking of what was the initial economic thoughts of the loss of future profits. And Wingtech has announced an investment arbitration claim. That's why I say it is just announced that it's supposed to be a USD 8 billion, expected to be brought under the China Netherlands BIT under the ICSID arbitration rules. So we'll probably get to see how the modern amended ICSID arbitration rules function. And on the facts, the investor will argue probably that the state's takeover and restrictions amount to indirect expropriation, because quite obviously that points towards it, and the breach of fair and equitable treatment, because let's face it, everything under investment treaty is FET. So now, including arbitrary interference and lack of due process, and also possibly free transfer of capital protections. Now, the Netherlands is likely to invoke its right to regulate for national security under general exceptions or otherwise, and arguing the measures were temporary, proportionate, non-discriminatory, and so on and so forth. Now, while the domestic remedies still remain available. Now, this makes the case fairly typical in one way because it is using BIT standards like expropriation and FET, but it is unique because it is squarely tests how far the national security and economic security justifications can limit investor rights in critical technology sector, especially in the so-called protectionist ways of thinking in the entire world, including EU and of course against China. So while we wait to see how this saga unfolds, I believe the triangulation of what constitutes the investor rights, the state's right to regulate, and national or economic security concerns, this triangulation would effectively need exemplification moving forward, especially if the reform is to be studied outside practice as well. And therefore, I believe that this is one case that I would look closely, and I urge anybody who's interested in the intersections of regulatory studies and substantive treaty obligations to also take a watch. Thank you.
Yes. Thank you very much, Kumar, for mentioning this case. It was indeed not too long ago that WingTech has filed a notice of arbitration. So I think this is a really good case to have an eye on come in the next month. And yes, to familiarize oneself with this kind of very interesting scenario. So now I would like to thank all of our speakers for those insightful reflections. Unfortunately, we do not have any more time to do a Q&A with the audience, but we would like to offer the option that any questions to the panelists can be sent to the IIDRC representative. I think the email has been communicated in the chat, and we can communicate it again after the webinar is finalized. So yes, I would like now to thank once again all the distinguished panelists for sharing their valuable insights and expertise on investment arbitration today, and your thoughtful reflections on the evolving balance between protecting investor rights and preserving state regulatory autonomy, India's unique treaty approach and the challenges tribunals face, and the broader global trends have provided our audience with a deeper appreciation of the complexities and opportunities in this field. So thank you very much.
I have a question. Sorry, Helene, sorry to disturb.
Of course.
Even though I have several questions, but unfortunately, because of the lack of time, I would be just requesting Mr. Kumar to share the case he just mentioned in the last, or in the Korea case as well. If you could mention, it would be very helpful for me.
It's called Nexperia, Nexperia, Nexperia versus Netherlands.
And the Korean case you were mentioned earlier?
Right, so that is Lone Star, LONE Star, SATAR.
All right,
versus
State of Korea. All right,
Yes.
thank you so much.
Of course.
Before we conclude, I would like to extend our sincere appreciation to our moderator and distinguished panelists for drawing on their vast judicial, advisory, and international practice experience to share such valuable perspectives. Your collective expertise in investment arbitration and treaty law greatly enriched this session and made it both insightful and impactful. We also thank all our participants for being an active part of today's discussion and for contributing to this knowledge-sharing initiative. E-certificates will be provided to all the registered attendees in 2 to 5 working days. We also look forward to welcoming you for our next session in the AAI series to be held on 7th March 2026 on ADR in Tech and Startup Conflicts, Founder Agreements, Software as a Service Disputes, and Digital Contracts, which is an increasingly sought-after field. In case of any query, you may reach out to us at the given contact details on the screen. Thank you all once again for your time, knowledge, and meaningful contributions. Have a very good evening.
Thank you, everyone. Thank you again, IIDRC.
Very much. Thank you.
Thank you, everyone. Have a good one. Bye-bye.
Thank you. Goodbye.
Thank you. Good evening.
Evening. Bye.